Joining me today is Jeff Kahane from Kahane Law Office, and we're going to be talking real estate law, specifically residential purchase contracts and resale condominium contracts. Jeff, thanks for joining me.
Thanks for having me.
All right, I guess the first question is, when most people meet you, either a seller or a buyer, it's after the deal has happened and they're there for the final signing of the documents. What's the most important part?
Well, almost important part is something that should happen before, where if people have any questions at all, they should contact us and ask, hey, I'm concerned about this, and we can look at it before things are signed. So we always try and encourage that.
All right. So do you have any specific issues that are most commonly crop up in terms of residential purchase contracts?
Yeah, certainly. So whether or not a buyer can actually purchase or a seller can actually sell. So for instance, a buyer may not be able to get their financing in place, and if a condition was waived before they had all of their approvals in place, or a seller, if they have dower rights that apply and their spouse isn't going to sign off on those dower rights, it can cause problems. So that would be a first kind of side on that side.
Financing is certainly an issue that causes a lot of deals to collapse.
Absolutely, and as long as they collapse before the contract is signed off and it's firm, that's a better time for that to happen.
So how do we get to that point?
Making sure that you have a final approval, because a pre-approval, people will assume is just, that's great, but it's only a approval in principle.
That's right.
And then the mortgage company will have to look at that specific property to make sure that that's approved and it goes through.
All right. Now we're looking at a residential purchase contract here that I have in front of me. This is a 6-page document. Now we can go through it, and there's some items on here that are fairly straightforward. I mean, the property description. You have unattached and attached goods described. Do you ever have any issues crop up with those?
All the time. So, I'm always surprised at the creativity of things that go missing that shouldn't.
I've had
front lawns, basements, furnaces. You just want to make sure that the contract is properly worded.
Excuse me, front lawns and furnaces?
Front lawn, all the sod rolled up and taken away.
Wow.
Yeah.
That's a first that I've heard. And a furnace.
And for a couple times, and it was my clients, and I think, like, did grandma give it to you? Was it very sentimental to you? The furnace.
So basically, when we're writing in the attached goods,
yes,
it should be anything that cannot be screwed, removed, or glued down, or whatever, something
basically.
like that.
And with respect to the furnaces, the people brought them back, and often with fridges, people bring them back. But you want to make sure that the contract is properly papered. So if you have a car lift in your garage, which is not bolted anywhere, it just sits there.
Right.
If that's supposed to stay, it needs to be written in, because it's not a fixture, it's not attached to the property.
Right.
Similarly, something like a wall safe, a seller should know that if it's a built-in wall safe, it's built in, it is a fixture, they can't take it. And we've seen both happen where people took things that they should not have.
What's the legal recourse in situations like that? I had a client that basically took a mirror in a bathroom.
Yeah, so the recourse is to sue for breach of contract. You can't automatically hold back funds. We can usually work out a negotiation with the lawyer representing the seller or the other side. And but otherwise, if they say, no, tell your client to go pound sand, if you don't pay the full purchase price, interest is charged at prime +3, and the recourse is small claims court. And it's a pain, it can take a long time. It is set up for a person to represent themselves. They don't have to hire a lawyer, because it's often not cost effective. That's the downside.
Right. Well, in the case of a furnace going missing, I mean, you're talking several $1,000s.
Correct. Yes.
Right. Okay.
Yeah.
So then we look at the purchase price and completion day, and this is important to note: vacant possession.
Correct. Although the contract has changed, so if there are tenants in there, now it's the seller's responsibility. In the old days, it was the buyer's responsibility to know what they were getting in terms of if there was a tenant or not. Now the seller has to make sure that they can give that possession without tenants, and it's at their cost if there are tenants they have to get rid of.
Sure, and when you have tenants, of course, you have to comply with the Residential Tenancy Act.
Correct, yes.
All right. General terms, is there anything in here that jumps out at you?
No, I mean, it's fairly broad. It's going to be situation dependent. I would add a general term that I think is, I mean, it's more of a general concept. Often the contracts come to us and people haven't been explained. They don't understand the different registrations on title.
Sure.
So things like restrictive covenants, encroachment agreements. By the time we're seen, if the contract's signed off on, the buyer is required to accept those things as they're on title,
right,
and may not fully understand what it is that they are accepting. So they may not be able to do that thing that they wanted to do on the property. Put in a gazebo somewhere, paint it bright blue, change the roof to a asphalt shingle from a wood shingle. And those are all things that should be reviewed with the buyer prior to them signing the contract.
Right, and those would fall under that restrictive covenant thing in terms of building additions, size, color,
all kinds of
architectural
registrations.
controls.
Yes.
And so it's very important then that the buyer and their agent sit down and go over the title and all of the instruments attached to that title.
Absolutely, before they even get to the contract, going over the title and also going over what are the things that are important for the buyer in terms of inspections. Most people get a home inspection,
sure,
but does a particular buyer have a concern about asbestos? Do they want testing, or radon gas, or engineering type things, or HVAC, electrical, all that kind of stuff? And then the buyer chooses. Our job and your job is very similar in that our job is about education and letting clients know, here's the different choices. What do you want to do? And they have to be the ones ultimately who make the choice.
Right, and it's all about that, making an informed decision.
Absolutely.
All right, let's turn to the next page here, Jeff. We've got deposits. You can have secondary or additional deposits paid. What kind of issues typically crop up on this area?
Most common, there's been a change in the purchase contract where deposits aren't being made on time.
All right.
And a seller has the right to walk away and void the contract,
sure,
if the deposits are not paid on time. So you want to make sure that they get in before the due date.